Welcome. I'm the president of Securities Arbitration Commentator, Richard P. Ryder. SAC will be your host today. SAC strives to be a pro-arbitration party-neutral force in its dispute resolution activities, and what we hope to accomplish in this and subsequent podcasts is to stimulate thinking about specific topics and issues of interest in securities arbitration, and to do so by bringing together people who are knowledgeable about and influential in the securities arbitration industry in order to discuss these issues and offer their personal insights and opinions. Listeners should keep in mind, please, that while our guests work for and represent various firms and organizations, their views as expressed in this podcast are not necessarily the views of those organizations. The ranks of the investment advisory community have grown rapidly over the past decade, as the asset gathering model has led to more wirehouse brokers migrating to RIA platforms and more investors, shaken by the tech crash and the 2008 financial crisis, have looked for professional advice as a protection against uncertain markets. Dodd-Frank in 2010 added more RIAs to the existing ranks, with the requirement that hedge fund managers and other money managers become RIA registered. At a time when the two disciplines, RIAs and BDs, are becoming more alike and even being forced into a consistent regulatory regime, the situation in arbitration could not be more different. RIAs are not required, as FINRA members are, to arbitrate upon the demand of a client. Advisor representatives are not required, as are brokers signing Form U4s, to arbitrate their employment disputes. Perhaps 40% or 50% of RIAs employ pre-dispute arbitration agreements, PDAAs, in their client advisory agreements, as contrasted with near-ubiquitous use of PDAAs among broker-dealers. And those who do utilize PDAAs do not have a developed and sophisticated SRO forum with oversight from the SEC. Yet, the SEC will presumably need to harmonize these two regimes using its Dodd-Frank Section 921 powers. In this fast-paced podcast, our panel, experts and practitioners in the securities dispute resolution field, will discuss arbitration as utilized today by RIAs and their advisory clients. To introduce our guest speakers and lead them in today's discussion, we've invited George H. Friedman to be moderator. George is an ADR consultant and SAC Board of Editors member. He retired in 2013 as FINRA's Executive Vice President and Director of Arbitration, a position held from 1998. Before that, he held a variety of positions of responsibility at the American Arbitration Association, most recently as Senior Vice President from 1994 to 1998. For the last 19 years, George has been an adjunct professor of law at Fordham Law School teaching arbitration. He serves as chairman of the Board of Arbitration Resolution Services, Inc., and is the principal of George H. Friedman Consulting, LLC. George holds a JD from Rutgers Law School, is admitted to several bars, and is a certified regulatory and compliance professional. George, thanks to you, and thanks to our panel for being here today.
Thank you, Rick. First, the legalities, if you will. Basically, don't steal this. Okay, moving right along, let me introduce our panel today. First, Glenn Gittimer. Glenn is chairman of McCausland, Keene, and Buckman's litigation practice, primarily focused on representing investors who assert claims against the financial industry. Currently, Glenn is on FINRA's National Arbitration and Mediation Committee and is a former PIABA director. He's a graduate of Indiana's University, Robert H. McKinney School of Law, and New York University. Thank you, Glenn. Next is Salvador Hernandez. Sal's a partner at Riley, Warnick, and Jacobson, PLC, regularly represents and counsels clients through complex civil litigation in both state and federal courts, as well as in the FINRA Arbitration Forum. He's a graduate of Vanderbilt University School of Law and Princeton University, and is a member of the Tennessee Bar. Next, Ross Tolman. Ross is senior partner of Trade Investment Analysis Group in Columbus, Ohio, That group provides expert witness services to counsel engaged in securities arbitrations and litigations. Ross has been an active participant in the dispute resolution process for more years than he probably wants to remember, but at least 25, and has provided testimony in both the state and federal court and arbitrations before FINRA and other SRO fora, AAA, and JAMS. He serves as an arbitrator for FINRA and the NFA, occasionally serves as a mediator, and is an active member and past officer of the Securities Experts Roundtable. Mr. Tolman earned his BA in English from Emory University and an MBA in Tax and Finance from Xavier University. He's a state-registered investment advisor, something of importance for our discussion here today. And last but not least, Jeff T. Zano is Vice President of the Commercial Division of the American Arbitration Association in New York. There he oversees administration of the large, complex commercial caseload, user outreach, and the panel of commercial neutrals in New York. He's been with the American Arbitration Association for some 25 years. Jeff's a graduate of Western New England University School of Law. Thank you, panel, for joining us. What are we going to be talking about here today? In the next 30 to 40 minutes, we're going to be discussing, as indicated here, the current federal and state regulatory landscape, what RIAs are able to, which RIAs are able to use FINRA arbitration, the advantages and disadvantages of that forum, similar questions about the American Arbitration Association forum, how do advisory clients fare in arbitration versus court, timelines, expenses, variables such as that, and finally at the end, our favorite part where we make predictions for the coming 5 years. Here are the core discussion topics we'll be looking at today. We'll begin with the state of investment advisor arbitration today, then go to what the parties want in this area, and then finally, where are we going to be 5 years from now, as I said. Let's go to the first series of questions. Our first core topic is the state of investment advisor arbitration today, and we have questions to set the background. Let me start with Ross. The first question, where are the cases coming from and who's administering them? Let's just start with the basics. Ross?
Okay. Most of the cases that I'm seeing are large firms, the broker-dealers, and they're broker-dealers operating on dual platforms. That is, they have clients that have accounts that are both investment advisory accounts and broker-dealers. And because of that, most of the IA cases I've seen are actually in FINRA. Occasionally I see some in the AAA, but because of the hybrid nature of most of these cases, they're actually in FINRA.
Any reactions to that? Let me start by picking on Glenn. What's your take on this one?
Yeah, George, what I've seen is somewhat different. I have seen cases against RIAs, which are pure RIAs. They tout the fact that they are independent from broker-dealers and broker-dealer products, and they use separate platforms, separate broker-dealers to house their securities. And it's quite clear that their decisions are in managing the account are independent from the custodial broker. In those cases, just episodically, I note sometimes there are pre-dispute arbitration agreements and sometimes they're not. And the ones that I see typically by default designates the American Arbitration Association. And we have experience in several of these cases under the American Arbitration Association consumer program, which will treat these arbitrations under their consumer rules. There are, of course, those cases where we do have broker-dealers involved who are also serving as registered investment advisors. And in those cases, clearly, FINRA is the default arbitration forum.
Okay, and Sal, Jeff, we'll get to you separately a bit later, but Sal, what are you seeing from your side of the table?
What I'm still seeing is the vast majority of cases are still being conducted with FINRA, as Ross said, because more oftentimes than not, even when you're dealing with an RIA situation, it's someone who is duly registered with a broker-dealer, and so the entire case matter ends up in FINRA. And so that's where I'm still seeing a lot of arbitrations being handled. I think since the passage of Dodd-Frank, and there's been a lot of discussion regulatory-wise about what happens when we have a true independent RIA. Should there be arbitration? Should it go to court? Those are all just questions right now that are in this state of flux because of the overlap and I guess shortcomings between the legal and regulatory landscape for an RIA versus a registered rep of a broker-dealer. And obviously that's one of the big discussions we're talking about today. But as far as where am I seeing cases coming from and who's administering them, there's no doubt it's still FINRA first and foremost.
Okay, well, it's a good segue to the next topic, which is the current state and federal regulatory landscape. Just to review, among many things, Dodd-Frank allows the SEC to establish a self-regulatory organization, an SRO for investment advisors. So, Sal, as long as you have the floor, what's happening in that regard?
Well, that is a really good question that everybody would like to know the answer to. Dodd-Frank was passed in 2010, and as part of Dodd-Frank, there's Section 913 or 913 of Title IX of Dodd-Frank. It required the SEC to conduct a study, and one of the things they were told to do or evaluate was the legal and regulatory gaps and standards in the protection for retail customers relating to all types of investment advice, whether it's pure kind of broker-dealer relationships or retired registered investment advice. And that study was completed. It was rather comprehensive in kind of studying the differences between the fiduciary duty standards, the regulatory schemes between a registered rep of a broker-dealer versus a registered investment advisor. And it seemed as if there was this momentum gathering to harmonize the two regimes. And as far as I can tell, there hasn't been much progress since then. I think the big question, will be, is FINRA the appropriate self-regulatory organization to oversee registered investment advisors, or should a completely separate SRO be established? Right now, the answer to that question is unclear. It seems to be in the commentators that I've read, everyone seems to think that FINRA is a logical entity to govern both. But I think that there are even bigger questions that will need to be addressed on the front end, whether or not if FINRA is the appropriate arbitration regime. Obviously the big ultimate question is FINRA the appropriate regulatory regime? And then if the answer to that is yes, then obviously I would think the answer would be yes. It's also the appropriate arbitration dispute resolution system as well.
Well, let's do a lightning round on the follow-up question to this one. We all know, most of us know, that Dodd-Frank also allows the Commission to ban or regulate or limit these pre-dispute arbitration agreements for BDs. It also allows the Commission to do the same for investment advisor contracts. So I'll go down the row here, but the question is, if let's assume Dodd-Frank, the Commission acts under Dodd-Frank to regulate PDAAs in broker-dealer contracts, would you recommend they do the same thing, take a consistent approach with RIAs? I'll just go down the row. You give us a quick answer. Ross?
Yes, I do. I think that they should do the same thing, and I think what they should do is put the RIAs, registered investment advisors, in a position to offer or actually compel arbitration in the broadest form possible, as many forums as feasible, not just FINRA or the AAA, as many as practically available. And the reason that I'm saying that is because I think if and when that happens, you're going to get, I believe you'll get pushback from the claimants or claimants plaintiffs bar, probably PIABA. And the best way to deal with that is to give retail customers the widest choice available in getting their due process.
Okay, Sal, your view on that? Same approach, uniform approach?
Yeah, I think it makes sense to have a uniform approach. I agree with Ross that more than one forum ought to be available to the customer, so the customer can make a decision regarding the forum.
Okay, Glenn?
Well, the difference really between, say, 3A and FINRA is that FINRA is a tightly regulated entity. It is overseen into great detail by the SEC. Its rules are all subject to SEC approval. I don't believe that the same type of oversight, for instance, if you were to give a choice between American Arbitration Association, Janssen Dispute, and FINRA, that the SEC can really get into overseeing the rule process and the oversight of those other entities. However, I think it's a good thing to have a choice of forum. So from a claimant's perspective, if you want a heavily regulated and arbitration within a very carefully defined and regulated forum such as FINRA, you can choose that, but you can also choose to go outside of that and choose to go to a forum which doesn't have the same level of oversight. But I think it would be a mistake to require, if 3A is available to the consumer, to have the SEC have the same type of oversight of American Arbitration Association arbitrations, as an example, as it has of FINRA. It would be the customer's choice to say, I don't necessarily care about having the SEC oversight and the promulgation of very specific rules as I would get in FINRA.
And Jeff, I know I haven't spoken for AAA in quite some time, but I'm guessing that AAA is okay on choice.
Yeah, absolutely. Multiple choices sounds like the right thing, the right approach. Absolutely.
Okay, and then briefly to keep us moving, there is state regulation as well. The states were given authority, meaning examination and regulatory power over RIAs with assets under management of $100 million or less. Just briefly to touch on that, we'd like to get a sense of what's going on. Now, Massachusetts Secretary Galvin did a survey in his state in 2013 of use of arbitration in investment advisor contracts. Just a couple of highlights before we get into what's going on in the state. They heard from about half of the investment advisors in the state. Almost all use written contracts, so it's not shocking. But about half use pre-dispute arbitration agreements. So that's an interesting development. I'll get to the AAA's portion when we speak to Jeff. But again, according to that survey, in the Commonwealth of Massachusetts, about half the advisory firms used mandatory pre-dispute agreements. All right, so what's happening? Glenn, briefly, can you tell us what you hear about the states and RIA regulation?
Very little. Here in Pennsylvania, I really don't think, and in the other states that I'm familiar with, there is a lot of focus on this focus on this subject. The fact is that I think that the $100 million and less threshold is making arbitrations with RIAs at that size, who are clearly independent of broker-dealers, much less of an issue.
Anyone else on states?
My comment would be that I have had interaction with the Ohio Division of Securities over the years. I've always had a pre-dispute arbitration agreement in my contract, and I've never gotten any pushback whatsoever, ever.
All right, let's move down to the last couple of issues. Jeff, let's give you a chance. You've heard the American Arbitration Association mentioned a couple of times. Now, that survey also showed that of those RIAs that are using mandatory arbitration agreements where they specify a provider, about 2/3 name the AAA, about 16% FINRA. So AAA is apparently a big player, at least in terms of the pre-dispute arbitration agreements that are out there. So let me start with the voir dire, Jeff. How many cases do you all get in about a year?
Well, no, everyone's right with respect to FINRA doing the majority of them. That's correct. It is not currently a big part of AAA's caseload. We handle about 250,000 cases a year. And out of that, with our consumer caseloads, about 1,300 consumer cases, and out of that, about 10%, 130, involve registered investment advisor type cases. The majority of our consumer cases are related to credit cards and auto dealership type cases. But in 2014, the AAA had over 400 security-type cases, business-to-business, that were filed under our commercial rules that were amended in October 2013. Some of these cases involved multiple investors, registered investment advisors, and the commercial rules were applied rather than the consumer rules. In 2014, I'm happy to say we saw a 7% increase in security-related disputes at the AAA. We are doing pretty well also in 2015. The types of cases that we see in these areas: failure to disclose risks, the making of false guarantees, unsuitable investment, or fraud. And then just touching on our panel just briefly, we have about 7,500 arbitrators across the country. And out of that group, 431 of our AAA arbitrators are experts in this area of security law, these types of disputes. Our panelists must have a minimum of 10 years of security-related experience, and they are all carefully vetted by vice presidents across the country and understand both our consumer and our commercial rules where these disputes are handled.
So what are the determining factors? We mentioned two sets of rules: the commercial arbitration rules, which have been around for a long, long time, and the consumer rules, which are somewhat more recent vintage. So what are the factors that determine what rules apply?
Sure. Well, I want to note that we have been applying the new consumer rules, these are new, on investment cases when the investment is for personal use gain and not invested on behalf of a company or business. That's the distinction right there. The consumer rules are not used for business-to-business disputes at all. The biggest change to the new consumer rules is that we are no longer using the supplement. We used to have a supplement that we referred to, the supplementary procedures, and now it's an actual rule set, which we think its standalone is much better, and it defines the consumer process much better. The new rules are consistent with many of the changes in our commercial rules from 2013 that were updated then, but the cost structure is different in the consumer rules, and we default to a single arbitrator in the consumer rules where unless the contract calls otherwise. In the commercial rules, the default is $500,000 and up. We go with 3 arbitrators. So there's a little distinction there. Another distinction with the comparing the consumer and the commercial rules is the rules on exchange of information between the parties is different. Rule 22 in the consumer rules is specifically tailored for a fast and economical process, much faster process. It's worded differently than our commercial rules. Also, a nice thing about the consumer rules is the consumer due process protocol that is referenced in the consumer rules. It ensures a fair process for the registered investment advisor and the individual investor for allowing a fundamentally fair process, independent impartial arbitrator, independent administration, quality and competent arbitrators, and I mentioned that before, and reasonable cost for the consumer, required convenient location. These are all part of the due process protocol, reasonable time limits, and most importantly, access to information for both parties, very important. And also in 2014, we launched the Consumer Clause Registry, where registered investment advisors and companies can register their clauses. Now, if they didn't register their clause before filing the case with the AAA, that's going to delay it a little bit. They have to come into compliance with the due process protocol. and register with the AAA registry, which is, I think, a great thing that we're now doing at AAA.
So you can cure the defect after the case is filed? Is that?
That's correct.
Hearing?
Cure the defect.
Okay.
Absolutely.
Okay. Now we're going to move on to the last bullet point, arbitration. FINRA. Just so you know, we did invite FINRA to participate. They declined, and none of us here is speaking for FINRA. But I'll ask Ross, perhaps, to summarize, the court question, which is under what circumstances do investment advisor disputes with clients end up at FINRA? So again, to restate, how do cases get to FINRA? Cases of this nature get to FINRA?
Well, far and away, and I would say this is probably true almost certainly true in 95% of the scenarios, it's where you have a retail customer who has accounts with a broker-dealer who is duly registered as an investment advisor and as a broker-dealer. The platform today, the most common platform you see, is that even if the account is primarily an investment advisory account, either using the firm's internal asset managers or third-party asset managers from the outside, almost all of these accounts, or all these clients, also have broker-dealer accounts as well. And the reason that they do that is they house asset classes, such as private equity, hedge funds, and structured products that are typically offerings, and the firm will not put those in advisory accounts because it's a double dip on the fees. So where you have these combinations, you've got a customer who does have a broker-dealer account, but he also has an advisory account fully, with an ADV form and a contract. Those, because of the dual registration, are typically winding up in FINRA, and that's the vast majority of cases. Now, I will say that although I don't think this was supposed to happen, over the years I have seen a handful of cases of non-affiliated advisors and their clients who slipped into a FINRA arbitration when both parties stipulated to the forum and both signed the uniform submission agreement, and for whatever reason, FINRA took it. I realize that's not their policy, but I did see that happen from time to time.
Yeah, what if you could hazard a viewpoint on this? Why do you think FINRA's, take on investment advisor cases where there isn't a BD dual registered person involved? Do you have any views on why they're taking that posture?
Yeah, I do. I think there's two reasons. One is they don't have any jurisdiction over non-members. So, what are you going to do if FINRA if a FINRA panel issues an award and there's an issue with respect to non-payment? The other scenario is, and I'm not sure how they would work this out, but if you're a non-affiliated person, an investment advisor, and FINRA sees something that's egregious, whereas on the BD side they might make a disciplinary referral, they're hamstrung. I don't know what they could do, because they don't have jurisdiction over these people. So that, other than that, I can't really see any reason why they wouldn't. But I'm trying to think through what the possibilities are. I think that those are two likely scenarios.
And you folks that are listening to this podcast can check out on the FINRA website. There is a special submission agreement that the parties execute in these cases. Again, cases where there isn't a dual registered BD involved. So in limited circumstances, FINRA will take the case. It's got to be a post-dispute agreement. There are several warnings given, as Ross pointed out. FINRA has no enforcement authority against a non-complying investment advisor. Parties have to agree that the award's published. So it's certainly worth taking a look at. Okay, let's. I think it's time to move on to our next topic, which is what do the parties want? Now we heard. We're gonna ask the main participants here to weigh in on this. I'll call on you, but we'll have a chance also to react to the AAA rules and which rules or which forum might be more appropriate. Let me start with factors that are important to RIAs. I'll ask Sal to address that. And while you're addressing that, certainly cover what factors in the AAA's rules make them attractive or, in fact, not attractive.
Well, thanks, George. Certainly, I think in order to answer the question of, what factors, do you consider in deciding to advise an RIA to utilize a pre-dispute arbitration agreement or not, is you got to ask, who are the RIA's clients? I mean, if the clients of the RIAs are larger type institutional type clients or clients with substantial assets, that RIA, they may want to remain outside of arbitration. And so why is that? That's because there are more procedures at their disposal. I mean, there's more expansive discovery. There's no question there can be depositions. There's motions to dismiss under Rule 12. There's an extensive summary judgment procedure. To the extent you are going to trial on those issues, you have a motion in limine practice to vet out evidentiary issues. All of these mechanisms are not necessarily available in arbitration, and so that's you got to ask, who are the clients of the RIA. Now, if there are also a number of reasons why an RIA may want to utilize a pre-dispute arbitration agreement. It's much faster. I've agreed with Jeff's comments wholeheartedly. The discovery is more streamlined. There's much less likelihood for the use of depositions. And while there's still a dispositive motion practice, it's in my practice, I've not seen it utilized that much, certainly not successfully. There's no jury, of course. The cost is much less. And when you're dealing with very small matters, relatively small matters, less than $25,000 in dispute, the AAA consumer rules even offer a docs-only process where essentially the parties submit on paper the matter, and then the arbitrator decides under R29 of the AAA new consumer rules. There's that process available. So those are the things that are attractive for an RIA in deciding whether to use a pre-dispute arbitration agreement. But then, of course, depending on who the clients are, the RIA still may want to remain outside arbitration.
Okay, let's look at the customer's viewpoint. Glenn, I guess the two-parter. First, litigate or arbitrate, and if arbitration, where?
Okay, I always prefer arbitration because in arbitration you don't have all the defense mechanisms that Sal has iterated at length and which cause extreme delay in getting the case resolved. I've had judges sit on motions for 6 months or longer at incredible expense, which is oftentimes crushing for the claimants. And I find that arbitration is almost always the fairest, the most expeditious way of resolving a case. As far as forum, I practice a lot, both in FINRA and more recently in 3A. I haven't had any securities experience in any other forum, but I think they each have their advantages, and I like them both. FINRA, of course, has very structured and well-established rules. They have a fairly decent arbitration pool in various jurisdictions. What I like about 3A, first of all, because the cases I take are mostly based on individuals. They come under the consumer rules. All the consumer has to do is pay a $200 filing fee. The other hearing session fees are borne by the RIA that has required the customer to submit to 3A forum. That's very favorable. Clearly, the expense of filing in FINRA is not that high, but that's a big advantage. The arbitration pool in 3A is very good. I mean, because they select from a small pool of arbitrators with substantial securities experience. And I have found that the arbitrators that have been appointed in my 3A cases are also FINRA arbitrators, and they are among the better, more experienced, and I believe the ones that will give a very fair shot to both sides. They tend to be very experienced attorneys in knowing how to run an arbitration, and I've had very good experience with the arbitrators that have been appointed. The FINRA pool tends to draw more from people who have interest in the securities field. It tends to be a little bit broader, but again, it's generally a fair pool. The promptness of the hearing in both fora is very, very important. I think 3As in the consumer rules, as Jeff has pointed out, is very, very effective in moving the cases along. Their arbitrators are educated as to the importance of a prompt hearing. There is flexibility in the rules, and this is somewhat as to the conduct of the hearing, what kind of discovery will be permitted, how many depositions, and if depositions are permitted, is largely left to the discretion of the parties, but ultimately to the arbitrator in 3A. And a lot of the rules in 3A are not as carefully defined as they are in FINRA, but generally the folks who run the 3A securities arbitrations are, again, very fair-minded and knowledgeable attorneys who know how to run the process. And I think with respect to the administration of the process, 3A has the flexibility not to be subject to very tight SEC oversight, so it is a little bit more flexible in dealing with it. I find both fora to be very favorable. I practiced very frequently in FINRA for many, many years, and now more frequently before the 3As.
Okay, and now for the expert's perspective, Ross, same core questions, litigate or arbitrate, and if arbitrating, where would you go?
Okay. Well, my strong preference is for arbitration. I've been in arbitration for 26 years. I think it's a fair process, and having been in also a fairly large number of cases in both state and federal court, I don't really see much benefit to anybody, except maybe for the attorneys working on the cases. But it's really an awful process for the plaintiffs and for the defendants, at least from my perspective. Now, in terms of where do you go, I think I agree with almost everything that Glenn said. I think I don't have any experience at all with the consumer arbitration rules for the AAA. All of my experience has been in commercial rules. So what I would say, comparing that to FINRA, there's some trade-offs. Compared to the commercial rules, the cost is astronomically higher in the AAA. I mean, it's relative to FINRA. The flip side of that, though, is, if you have a very large, complex case, perhaps that case can bear the, burden of the cost. Smaller cases, I don't think so, and I don't know exactly how the consumer rules work out because, again, I haven't had any experience with it, at least not yet. Quality of the arbitrators, I think generally quality of the arbitrators is good in both forums. FINRA has, I would say, a little less consistency than the AAA. My experience, the AAA arbitrators operating under the commercial rules are absolutely the finest arbitrators I've encountered. They're very dedicated people, and I have nothing good to say about them. Nothing bad to say about them. Everything's good. And my last point is that the AAA does tend to be more like a court proceeding. Depositions, which you never get in FINRA, are very common. I wind up writing a lot of reports that look like Rule 26 reports. So it's not quite the cowboys and Indians scenario that you get in a regular FINRA arbitration.
Jeff, I just want to circle back to one point on the costs. If a case is under the consumer rules, as I understand it, I should know, I'm on the panel, AAA panel, I took the training, the fees are much lower. Is that correct?
Yeah, it's much lower. Like Glenn mentioned, I think the consumer pays $200 for any of the types of arbitration, the desk arbitration, or an in-person telephonic with a single arbitrator, or an in-person or telephonic with 3 arbitrators. It's still only $200 for the consumer. For the business, for the investment advisor, the filing fee for desk arbitration is about $1,500, and then the arbitrator's compensation is $750 for the 1 day. For the in-person with 1 arbitrator, telephonic, the business would pay a $1,500 filing fee, and the arbitrator would get $1,500. So it is minimal. And then with the 3 arbitrators, the filing fee goes up just slightly to $2,000, and then the arbitrator compensation stays the same at $1,500. But there is, like was just mentioned, there's a big price difference in comparison to the commercial rules of the AAA.
Okay. All right. Now on to our third group of questions. Not really questions, but topics. I'm going to ask each of the panelists to weigh in succinctly on where they think we're going to be 5 years from now. Some of the issues you might touch on, is FINRA going to be handling IA disputes? Should it? AAA for that matter. What else might happen? What changes are needed? Where do you, if we do this podcast again in 2020, what are we going to be talking about? So let me start. I'll ask Glenn to weigh in first on that.
Well, I think the important thing coming forward will be choice. As we've mentioned, FINRA will take these cases, and I've asked my opposing counsel to agree to post-dispute arbitration agreements when they're not FINRA members. So there will be choice whether it all comes under FINRA's jurisdiction or not. I think it's important to continue to have a selection of forums which are available to handle these matters, but I think as well there's going to be greater a move towards SRO regulation of the RIAs, and I think it seems to make much greater sense to do that under the umbrella of FINRA rather than building an entire new house from scratch.
Okay, thank you. Sal?
Yeah, I agree with Glenn. I think that the obvious, prediction to me, and well, first let me say I have no idea what's going to happen in 5 years from now, but it seems to be a good prediction that FINRA would be handling IA disputes on more of a formal process and not through the necessarily the guidelines that FINRA has released from a couple of years ago, and I think that that could be more easily established even before there's further harmonization. And I'm using that word because that word's used a lot in the Dodd-Frank study. The harmonization between the fiduciary standards of an RIA, which is more stringent than the fiduciary standard of a registered rep. So that's my prediction, especially since we're going to see and are already seeing more dual licensed RIA/registered reps and more pure RIA, completely independent fee-based type advisors.
Okay, thanks. Ross?
I think FINRA is going to go where their members go. And the members are clearly moving to the IA platform. And they're doing this to capture a more consistent revenue stream because of the continuing fee structure. And they're also doing it, they're going to have to do it because they're going to need to do that to keep their producers from migrating to fee-based platforms elsewhere, which has been happening for quite a while. And so FINRA is going to face a choice. Either they're going to arbitrate the issues that their members are involved in, or they're going to get out of the arbitration business. Because if they try to keep this thing focused on the transaction-based broker-dealer, I just don't think in 5 years there's going to be much of that business left, at least not on the retail standpoint. Now, member firms, that's that's a different issue. You know, that transactional side will still exist. But for consumer arbitration, you know, I think FINRA will definitely, you know, migrate to the IA platform.
Okay, Jeff, what are your thoughts on this?
Well, I'm optimistic we're seeing some growth here at AAA, but I hope FINRA, AAA, and other administrative agencies continue to get the word out about the advantages of ADR. There are so many advantages. We discussed on a lot of them today. I think it's very important to get the word out. Also, I believe the new AAA consumer rules and the registry is going to go a long way to making people feel comfortable using this process.
Yeah, I'm going to call it myself. I haven't weighed in on too much substance, but this topic is too much fun because people can't say I'm wrong for sure. They can just disagree, unless you claim to be from the future. So, well, in 5 years, someone will be the SRO for investment advisors. I think it'd be untenable for 10 years to elapse from the enactment of Dodd-Frank for that issue not to be addressed. The fiduciary issue will be addressed as well. Those are not difficult predictions to make. I agree with what I've heard about the migration to the RIA model. It's continuing to happen. Now, as regards to arbitration, I do think FINRA and AAA, but FINRA will still be handling arbitrations, and I think I agree also on a more formal basis. By that I mean, as I said, I think the SRO issue is going to be resolved, and whether FINRA is the SRO or some other entity is, I think FINRA is uniquely positioned to actually do the arbitrations. It's not shocking or unusual for FINRA to be the arbitration forum for different SROs. There are several now several SROs that provide for FINRA to actually handle the arbitrations. So I think pretty much no matter how the SRO issue works out, I think FINRA is going to end up doing the arbitrations as it does for others, and there'll be some harmonization between the current rules that really are set up for VD cases and cases involving registered investment advisors. All that will be worked out, so when we get together in 2020, we'll be able to talk about what's happened. Anyway, those are my thoughts for the future. Well, I see our time is up. I want to thank our panel and SAC for a great, interesting program. I know it could have taken another hour easily to go through all the issues, but great job, Glenn, Jeff, Ross, and Sal, and Rick. And thank you, audience, for listening. Now, be sure to follow the panelists and SAC on Twitter. The handles are indicated here on the slide. We'll have another podcast coming in the fall, topic to be determined. If you have thoughts on that, let us know. And please take a look at SAC's website at sacarbitration.com to learn a whole bunch of other things. Thank you very much for participating. Take care.